Here to talk about that is Steve Gersten. Steve is a partner in the Gersten Law Firm, one of the powerhouse, maybe the powerhouse firms these days in auto negligence cases. We've got our president, Bobby Raitt, from the Gersten firm. Dave Christensen will be speaking later, who's an outstanding trial attorney. And Steve, I've lost track of how many million-dollar verdicts he's had. He knows his stuff, and I'm really looking forward to hearing what he has to say this year about closed head injury exception.
The first strategy, the way I want you to think about this, is what I would call the automatic strategy. And then you have the second strategy, which is the traditional, which is creating the material question of fact. Now, some of you may be wondering why I use the term automatic instead of the term affidavit. That's because we now have an incredibly important decision that came down 2 months ago that is published that uses the word automatic. And this is a word that we should all embrace. What Minter says is if a properly qualified doctor testifies, and it can be by affidavit, that there may be a serious neurological injury, automatically get to a jury. It's very good language. That should be the end of the inquiry, but it's not. Also published and lurking out there is a case called Churchman from 2000. Now, in Churchman, the doctor actually went beyond the statutory requirement, and instead of saying that there may be a serious neurological injury, he actually went beyond that and said, I am diagnosing a closed head injury and a traumatic brain injury. And the Court of Appeals said, not so fast. Even though you've gone beyond, in theory, what the statute requires, you haven't told us how that closed head injury or traumatic brain injury that you have diagnosed actually impact upon the plaintiff. And you have to do that. So it's not just saying that there may be a serious neurological injury. It's not just saying that you have a traumatic brain injury. You actually need to, in your affidavit, even if you're taking the automatic approach, I believe, have to address the impact of how the closed head injury is affecting your client's functioning. Now, just going back for a second. Let's see. Okay. Now, one thing I want to get off my chest about Churchman, because a lot of you are probably looking at this and saying, wait a minute here. The statute only says, you know, there may be a serious neurological injury. But in Churchman, the court picked up the dictionary again and looked up the word serious in Black's Law Dictionary. And in Black's Law Dictionary, serious is defined as must be dangerous, potentially resulting in death or other severe consequences. You wonder how in God's name do we get from a statute that says may to a requirement that you now shall or must show the effect, the functioning on the plaintiff. 3135 says may. Churchman says must be severe, potentially resulting in death or other severe consequences. It makes no sense. The court in Churchman would have been better advised to look up the word may, as in may be a serious neurological injury, which Black's Law Dictionary actually warns lawyers and judges, please be careful that you don't misconstrue the word may with shall, that justice be the slave of grammar. So unfortunately, Churchman is out there, and if you have a judge, you know, the nice thing is this, just taking a step back for a moment. When you show the court the Minter language, for most trial judges that should be enough. But if you have a judge that's going to require Churchman, or if it's going to be appealed to the Court of Appeals, you better embrace some of the language from Churchman and show the impact, the functioning on the plaintiff, if you want your case to survive. Now, the question is, how do you get your treating doctor to use this language? In my materials, you don't need to turn to it now, but Exhibit 3 is the affidavit that Tim Smith used from last year. And it's a very good affidavit. Tim is a friend of mine. He's a very fine lawyer when he's not fishing. He did a great job, but the key thing I want you to note is that in Tim's affidavit, he has this paragraph here. If he did not have that paragraph in the affidavit, I believe that affidavit would be defective. So how do we get the doctor to be able to write those kinds of words in the affidavit? And the one thing I would say, and I have said it before, is embrace the medical literature. Remember, by definition, a traumatic brain injury increases your risk, your susceptibility to Parkinsonism, to dementia, to early onset Alzheimer's. This is all in the published peer-reviewed medical literature. The rates for suicide, the rates for divorce skyrocket compared to the normal population. Reserve brain capacity it basically means a second or subsequent injury to the brain is devastating, can have devastating consequences. There was a great study that came out for us 2 weeks ago. It came out on May 31st talking about how NFL players who years and years before when they were playing football were diagnosed with concussion, how they later in life have gone on to have severe clinical depression. And there clearly is established now a direct relationship and correlation between concussion or brain injury and later episodes of severe clinical depression that is significantly statistically different from the normal population, and it affects life expectancy. Continuing with more happy news, let's turn to the traditional route, which is the traditional material question of fact. Obviously, there are 3 prongs: objective manifestation, important body function, affects normal ability to lead your normal life. The key thing, as Wayne had mentioned, is we have a problem because it's real hard to show or objectively manifest a traumatic brain injury. The problem is that after Netter versus Bowman came down in September of last year, there are now a number of defense attorneys that are saying, wait a minute, we now can say, and if you've got a case with Jerry Swift or a couple attorneys at Plunkett Cooney, this is what they are now doing. They are now saying that objective manifestation does apply to traumatic brain injury cases. So how do you respond to this argument? I think, and this is Netter versus Bowman, by the way, that, just to take a 1 minute aside, Netter versus Bowman is a really evil decision. Where basically the court, you could just imagine these guys sitting around saying, not enough cases are being dismissed under objective manifestation. We have to do something about this. So Netter versus Bowman comes down, and basically in Netter they say, well, Jackson versus Nelson, which is the published case, we have to follow it, we're bound to follow it. But then on the very next page, they come down with an entirely new definition, which is clearly harsher than the definition in Jackson versus Nelson. So this is a new definition that a number of defense attorneys are now arguing should be applied to your traumatic brain injury cases. That the injury be either A, visually apparent, or B, capable of detection through the use of medical testing. One of those two. So what is your response? It's a nonsense argument. Clearly, it makes no sense to have a closed head injury exception if you still have to show objective manifestation. The whole reason why we have the exception to begin with is because you can't show objective manifestation with a lot of these traumatic brain injuries. And Guerrero versus Smith is a great case to support that argument. Even Talbot, in his dissent, clearly says the trial court erred in ruling that the plaintiff attorney had to show an objective manifestation on a traumatic brain injury. Trap number 3. What happens at the end of the case when the defense attorney says that the objective manifestation definition should still be read to the jury in the jury instructions and it should be on the verdict form? I think